Elon Musk, the innovator, the risk taker, the face of Tesla, secured a $55.8 billion payday. That's the largest compensation package in corporate history. But now a Delaware court hit the brakes, questioning whether this deal crossed the line between bold leadership and corporate excess. The case, Tornetta v. Musk, isn't just a legal battle. It's a flashpoint for deeper questions. How much power should we give to visionary leaders? When does rewarding innovation become exploitation? And can corporate governance rise to the demands of an increasingly unequal world? Welcome back to Organize, the business law breakdown. I'm your host, Professor Seth Oranburg, and today we're diving into a case that challenges the very foundations of corporate America. This isn't just a courtroom drama, it's actually a referendum on how we think about leadership, fairness, and the role of corporate players in society. At the heart of Tornetta v. Musk is the question of accountability. How do we reward transformative leadership without giving rein to unchecked power? To help us navigate these murky waters, I'm joined by two of the brightest minds in corporate law, experts who bring sharp analysis and distinct perspectives to today's conversation. First, we have Professor Stephen M. Bainbridge, William D. Warren Distinguished Professor of Law at UCLA School of Law. Steve is a prolific scholar whose work has shaped how we think about fiduciary duties, shareholder primacy, and the delicate balance of power in corporate governance. Steve, welcome to the show.
Thanks, Seth, for having me. This is a fascinating case with a lot of important social and legal implications. So I'm really looking forward to the discussion.
Next, we have Professor Anat Alon-Beck, Associate Professor of Law at Case Western Reserve University School of Law. Anat is a leading voice on shareholder rights and accountability, with her work pushing the boundaries of how corporations can and should serve their stakeholders. Anat, it's great to have you back on the show.
Thank you so much, Seth. I'm excited to be on your show again to discuss Elon Musk and, of course, to dig into this case. I think it raises so many important issues about power, about fairness in the corporate world, and I'm looking forward to having Professor Bainbridge here with us today.
Awesome. So here's how we'll break it down today. We'll start with the specifics of Tornetta v. Musk, the arguments, the decision, and its immediate impact on Tesla. And then we'll broaden out to the impact on Delaware corporate law and zoom out further to broader implications. We'll try to answer questions like what the case means for corporate governance, the role of courts in corporate America, and public trust in our major institutions. And finally, we'll tackle the future. How does this court shape executive compensation and the evolving expectations for corporate leadership? So let's dive in. Steve, what's your first impression of this case? Does it reflect a significant shift in corporate governance? Or is this really just a one-off reflecting the uniqueness of Elon Musk's position?
I don't think it's a one-off. I think that the case can be looked at in two dimensions. One is the perennial question of whether Delaware corporate law is an appropriate vehicle for solving societal problems. And I'm thinking here particularly of how we go about regulating executive compensation and the alleged contributions that excessive executive compensation contributes to wealth inequality and various other social issues. The other perspective, of course, is a more technical legal perspective. The case is a major milestone in the ongoing evolution of Delaware law dealing with conflicted controller transactions. And as a technical legal matter, the case raises a number of areas of Delaware corporate law that I personally have gotten off the track.
Anat, do you think that this case represents Delaware corporate law going off the track, or does this track with how Delaware corporate law has been to date? Do you see this as a shift, or is this just a application of the laws?
So personally, I feel that it is an application of the law of the way it is. There are some developments with regards to corporate accountability. But of course, the implications, I think, extend far beyond executive compensation. I think at the core, this case underscores the evolution of how corporate law controllers exert influence, not just through sheer ownership, but through mechanisms that blur the lines between governance and accountability. I think you can say that there is some norm shifting with regards to corporate accountability that goes beyond ownership and that is controlled through governance. And it's nothing new. We are seeing it now. We're seeing these discussions in mechanisms such as dual class share structures, in controlled board composition, in different types of contractual agreements that entrench power. And of course, we also have to bear in mind, just like Professor Bainbridge has mentioned, and that is we've had some amendments. For example, if we take into account the DGCL amendments and the Moelis parallel, we've had some amendments last summer which allowed boards to contract out of their governance rights. And so these changes, or perhaps if we take it all, then we need to think about the limitation to fiduciary oversight, to governance terms in contracts, whether they are entrenched, and overall how we want to look at traditional equity-based accountability mechanisms.
I want to make sure some of our listeners who are familiar with the terms of art are with us here. So I want to dig into the conflicted controller transaction concept just to make sure we've illuminated what that means. So my understanding of a conflicted controller transaction is when a controlling shareholder or a shareholder who has a substantial interest in the company, meaning owns a lot of the stock or a majority of the stock, has interests that conflict with the minority shareholders. Now, in the case of Tesla, I don't know the overall ownership picture, but can you, Anat, paint that picture a little bit more? Do you have, what about this situation did Musk have some kind of control? Because he's the CEO. I thought CEOs can get fired by the board. What's the big deal here?
So really the way if you look at the broader context, you have to look at corporate controllers as the architects of influence, right? And there's a few ways you can look at the issue of control. First, and I want to make sure that it's clear, it's not just about compensation, right? And it's not just about how much stock do you hold. You have to look at overall what we have today is this trend. And by the way, it's not unique. We had that before, even with Ford and other famous CEOs. You have CEOs, whether it's Musk with Tesla or you have Jeff Bezos and others, that are becoming a brand of themselves that is associated with the company. And the question is, how do we hold them accountable? When perhaps, for example, with Musk, he only has 20% of the stock. But the question is, does he have control over the board? Does the board listen to what he says, or are there more checks and balances, or he exercises more control over the company? And so we really have to think about also shareholder voices, right? Who exercises governance and utilizes governance structures? Who exercises authority? And I think Arrow, by the way, the Nobel Prize laureate, have always discussed this, that we have this challenge, right? We want to give the board authority on the one hand, but then we want them to be accountable on the other. So how does that balance change where you also have a controlling shareholder? Like,
Steve, do you agree with that definition? I go back to the term that Anat used. I like this. Architects of influence. How do you understand when we have a conflicted controller transaction? And did we have one here?
If you'll permit me, I'm going to put in a plug for my new article, A Course Correction for Controlling Shareholder Transactions, which is up at www.com. I think that the Delaware courts have significantly broadened the definition of control in recent years. And when I say the Delaware courts, I particularly would point to Vice Chancellor Travis Laster and Chancellor Kathleen McCormick, who wrote the Tesla decision. And what they've done is to move from a historical function focus on share ownership towards what Anat refers to as other modes of influence. And so managerial authority or contractual leverage have become mechanisms by which they conclude that somebody controls the corporation. And that trend has created a lot of ambiguity, with courts emphasizing influence over formal voting control, which has led to, I think, a lot of uncertainty about who qualifies as a controlling shareholder. And essentially, I particularly focus on the point that Chancellor McCord made in the Tornetta case, which is this academic idea of the superstar CEO, that these superstar CEOs like Bezos and Musk and so on are so influential that they are effectively controllers. And the problem with that, one of the things, is that Delaware law has always distinguished between how we analyze controller transactions and how we analyze transactions by directors and officers. And we can get into the details if you're interested, but basically, transactions involving controlling shareholders are subject to much more stringent review than transactions involving directors and officers. And what cases like Tornetta had done is to blur that distinction. And the logical endpoint of cases like Tornetta is to essentially say you don't really even need to own stock in order to be a controller. If you're a sufficiently superstar CEO, that makes you a controller. And that just eviscerates that distinction that Delaware law has traditionally brought.
Yeah, and what does that even mean? What percentage, how much influence, how many likes did you get this week on TikTok in order to be a superstar? That's a pretty vague term. So I would imagine that vagueness is a problem for people that are trying to mitigate risk because you just don't know who qualifies in that category or not. And it's all something that could shift over time because there are superstars that rise and fall. But the term superstar CEO really does bring home the point that this case seems to be about power dynamics and about who has the power. And there is even an article in the Wall Street Journal that basically said this one shareholder, Tornetta, took over the power from the whole company and upset the balance of the shareholder enterprise. The shareholders voted twice to give this guy a huge pay package. And a single shareholder, I don't know actually if there were, I don't believe it was a class action, but he basically ran a lawsuit that stopped that from happening. And this claim of the superstar CEO that you've got a public face, a visionary, an influential decision maker. Anat, given what Steve said about the difficulty in pinning down what superstar CEO means, do you think that term, superstar CEO, is a good way to describe who is an architect of influence?
First of all, I love the term superstar CEOs. And I want to emphasize something that I think it's important here and add to it. And that is, think about the court's role, right? Overall in corporate governance, and particularly in these Tornetta cases where we're going to have these superstar CEOs. And by the way, I write about unicorn firms. And guess what happens in the unicorn sphere? We also have superstar CEOs and unicorns, right? There's a reason why somebody that's running a startup is able to raise billions of dollars, right? This is something we haven't seen before. And so we're going to have more and more of these companies where we have these CEOs that are very influential and their brand is associated with the company brand. And so if we look at the court has to maintain this delicate balance, again, between accountability and effective decision making. And let's think also, what about obligation? Should the court think about the corporate form as an entity? Should they think about the collective shareholder? What about the minority shareholders? What about the dual nature, right? On the one hand, you want the court to navigate these complex governance disputes. On the other hand, to exercise some sort of fiduciary oversight. And then, who do we want the obligation to run to? Is it to the corporation? And who is the corporation? Is it just Tesla? Is it Elon Musk's interests as a controller? And by the way, he might have interests that may diverge from those of the corporation or from the other shareholders. Not when we talk about shareholders as a collective group, we don't just take into account a majority block or a dominant controller, right? And so whose best interests are we trying to prioritize here? And how do we make sure that corporate decisions align with shareholder value, right?
So there's a lot to unpack there. I'm going to try to simplify and just focus on one thing at a time. So let me take it back to Steve. We can make sure the audience kind of follows along, right? And the point there was, what is the role of the court? So I think that Anat brought that up in there. And one of the points you raised was that courts should be balancing this power, and that's an important role for them to play. I wonder if you have a different perspective on what courts should be doing here. You started off by asking, is Delaware corporate law the right vehicle for solving social problems? Are Delaware courts the right place to figure out whether or not someone's a superstar CEO and whether they have power?
The Delaware courts are not a legislator, and that's important. Historically, when we've had things like the tech stock bubble burst in 2000 and the federal intervention in Sarbanes-Oxley, or the financial crisis of 2007, 2008, and the federal response in the Dodd-Frank statute, the Delaware courts were very careful to stay out of those sort of big policy disputes. They stayed in their lane, and their lane is deciding individual cases based on sound corporate law principles. That's the trade-off that most of my scholarship has been devoted to. The problem in corporate law is we rely on cases, and nobody's ever brought a case where they went to the Delaware Chancery Court and said, we've had a hugely successful year. Our CEO is doing amazing. Would you mind writing up an opinion for Atlantic Third about that? All of our cases are cases where there's been a failure, and that biases us in favor of accountability. And we lose focus on the need to preserve authority. We lose focus on the idea that it's important from the corporate perspective to have a voice within the corporation that can make decisions that are final and binding. Supreme Court Justice Robert Jackson famously said that the Supreme Court is not final because they're perfect. They are perfect because they are final. And that's true of the Delaware courts when it comes to corporate law. But the Delaware courts need to remember that they're not a super legislature. They're not also a super board of directors. That ultimately what the court ought to be striving to do is what it has historically done, which is to emphasize the role of the board of directors. That has the board of directors functioned independently in good faith? And if so, the court should simply defer. And that's an issue that Tornetta raises, which maybe we can get into. It's part of the evolution of the law in this area that I'm critical of is the evolving treatment of independent directors or director independence. And I think that this case, among others, illustrates how much more intensely the Delaware courts are focused on issues of director independence and finding people who I think, frankly, any reasonable person would think would be independent to not be. I think they've tightened up that standard so much that it's getting increasingly hard for somebody to be an independent director in Delaware.
So they're focusing more on independent directors and fewer people qualify as independent directors, which means the court gets more power. Don't organizations do that? Organizations try to increase their scope of power. Why would Delaware be any different? Is the Delaware court expanding its scope of influence? And isn't that just the natural way that bureaucracies and organizations unfold over time?
So I actually want to build on Steve's perspective here. And I think what's also happening here in the background, and I'm trying to explain this phenomena, is that we have this reemergence of leader-centric corporations. So historically, we had that before, like during the Ford era, but then companies tried to distance themselves from being tied to a singular personality, right? Because they recognize this potential for misaligned interests, especially in this case where Musk is also a CEO of so many other publicly traded firms and privately firms that are affecting our market. But today, by the way, Musk is not the only one. We have these high-profile leaders that are often the public face of their organizations that shape the reputation and strategic decisions of the firm. And that creates some sort of a paradox, right? And as a result, we have this rise in shareholder activism. It's a response. Shareholders are increasingly vocal about holding these leaders accountable. And as we know, shareholders don't have a lot of rights. They don't have a lot that they can do. One of the tools that they have in hand is to bring this litigation. And I know even the litigation is contested, right? Even the whole aspect of shareholder litigation. But this case that was brought against Tesla and Musk illustrates, I think, a broader movement where shareholders argue that corporate governance must prioritize the company and the shareholders' collective interest over particular interests. And then there, I think it puts also that what also puts the court in this position where they have to take into account the public trust and the market implications, especially when companies become synonymous with their leaders and the public trust becomes intertwined with the leaders' behavior and decisions. And there's scandals and there's all kinds of allegations of conflict of interest, or there's good or bad governance, and how that affects the company's reputation and the stock performance. And so what we see here is some shareholders, usually minority shareholder, recognize this dynamic, and then they use litigation, they leverage litigation, they leverage activism, and they advocate for change. And that puts the court in the center of all this. So I think we really need to look at the whole system, right? And how is the court reacting also to this surge in shareholder activism?
If I could just jump in, I think you make some great points. And I would, though, separate out two issues that I think you're touching on. One of them is the role of shareholders, and the other is the role of the courts, and particularly the Delaware Cords. And as I have a much more restrained view of the proper role of shareholders, I wrote an article a long time ago called the Case for Limited Shareholder Rights. I think one of the reasons why we have authority as a virtue in the corporation is precisely because, and this gets back to Kenneth Arrow's work we both rely on, that when you've got a large group of decision makers with differing interests and differing knowledge, it becomes very difficult to use participatory democracy as a decision-making tool, and you need centralized decision-making authority. And so I'm not a big fan of shareholder democracy, but setting that aside, 72% of the minority shareholders voted on the second vote to re-approve Musk's pay package. They've approved it twice now. And the second time they approved it, the proxy statement they were giving had Chancellor McCormick's original opinion. And so they could read it and decide whether they agreed with her or they agreed with their board. The other thing that I think you raised that I think a really interesting thing to talk about potentially is the Delaware judges, I think, know that they are making law in the shadow of the importance to the state of Delaware of being the home of American corporations. In a good year, Delaware gets as much as 20% of the state's tax revenues from franchise taxes that are paid by corporations for the privilege of being incorporated in Delaware. And we think of Delaware as being the dominant player in the market for corporations, but it wasn't always so. 100 years ago, 120 years ago, New Jersey was the dominant player, and New Jersey made a series of legislative decisions that they lost it, and companies migrated to Delaware. I have a new article out called Dexit, which is a review of companies leaving Delaware for other jurisdictions. And one of the things I've found is that a lot of the companies that are leaving Delaware and going to places like Texas and Nevada were controlled companies. Elon Musk moved Tesla to Texas. He moved SpaceX to Nevada. And the Delaware judges have to be aware, at least in the back of their mind, that when they make these sort of decisions, they're essentially making tax decisions about how heavily their fellow citizens are going to be taxed. And they're messing with the goose that laid the golden egg. And how that incentivizes them has always been a really fascinating discussion.
I can totally see why a controlling CEO or a superstar CEO who wants to retain that control would choose to use the control to go somewhere. He's allowed to do that. And you can reincorporate in other states. So there's this longstanding race to the top, race to the bottom kind of argument about corporate law that is relevant here, but it's important to note that corporate law is a competitive marketplace. You can choose where you want to incorporate without having to physically relocate your headquarters. And you do see Elon Musk in particular threatening to get out of Delaware all the time. And that costs Delaware money, and people do respond to financial incentives. But I do want to maintain the separation between these 2 points, role of shareholders, role of courts. And we'll come back to the role of courts and maybe whether Delaware is going to thrive or is basically going the way of New Jersey at this point. But sticking with the role of shareholders here, there's a big important debate as well. And Steve, we know where you're at on this. I analogize quote unquote shareholder democracy to more of like how we use the term democracy in America. We live in a republic. You don't get to vote on everything. You get limited voting rights. And then some person that you appoint goes and makes laws for you. And then they appoint somebody who makes regulations for you, and et cetera. In a corporation, it's even more. And the reason is efficiency. You can't, first off, I don't want to make a vote for every corporation I have stock in. I have some index fund. The index fund probably has 17,000 different stocks in it. I don't want to make all the decisions for all those companies every day. It's not worth it. It's not worth it to me. I'd have rational apathy. So instead, we have this idea that we delegate power, and we have agency law that provides, and corporate law that provides responsibilities to those delegates. It sounds like you think that works really well. That's why corporations work, Steve. So I want to ask you, Anat, why you seem to be championing the little guy? Like here, it seemed like you seem to say that a small shareholder, even though 72% agreed, one of them saw something wrong with this picture. And that person brought the whole situation to justice. Can you elaborate on that?
Sure. And I also wanted to touch on 2 issues in the Tesla case. But let's first start with that. And that is, like I said, even this whole concept of shareholders own the company. I'm like, really? I don't know. I always like to give that example. One stock in Microsoft. Do I get to tell the board what to do? I don't really have that much power in a large publicly traded firm. But that being said, I do have some, and that's with regards to the litigation. Now, and we know the derivative litigation is being used. I do want to raise 2 issues with regards to the Tesla case. One is the issue of the uninformed vote. I'm not going to go too much into this. According to Chancellor McCormick's view, there was a materially misleading proxy materials. That's one. Second, which I think is even a more important point, and that is the improper use of the ratification. Let's just talk about that for a second. So Musk's legal team relied on ratification. And that, I think, the way they did it was flawed. I think they could have fixed it if they did the ratification during the first litigation, okay? So in Delaware law, ratification is an affirmative defense. And that has to be raised during litigation, not as a post-trial remedy. So this is where I think that's what the lawyers should have done. So I'm sorry, but I'm putting the responsibility on the lawyers here. They should have done that during the first litigation. They should not have done that post-litigation. So they failed, I think, to provide a common law or statutory basis for their arguments. They didn't meet the threshold that was required under Delaware law precedent. And so I think that kind of complicated their defense. But it's just my opinion with regards to that. And I think Steve has a comment on that, please.
Yeah.
I think you make a great point, but when you blamed the lawyers, I would just want to raise an alternative idea, which is I've been following Elon Musk's career for a long time now, to the point where I actually taught a course entitled The Law of Elon Musk a few years ago. I have a suspicion that Elon Musk is an extremely difficult client, and especially having talked to some of the lawyers that worked with him over the years. I know that Chancellor McCormick, in her opinion, shooting down the ratification argument, and I totally agree with you that, by the way, the ratification argument that they ran up the flagpole, I thought was always going to get shot down. She blames the lawyers for making an innovative argument, if you will. I think Elon Musk drove that. I think Elon Musk came up with the idea of having another shareholder vote to prove how much his shareholders love him and to rub that in Chancellor McCormick's face. And then the lawyers said, oh, not okay. And they did the best they could with it. But it reminds me of when Elon was taking over Twitter, not taking over Twitter, spewing people over Twitter, being sued over Twitter and just watching this incredibly difficult to control client, I'm sure giving his lawyers serious ulcers trying to control this guy. And maybe this is a feature of your superstar CEO thing, that these people just have such enormous egos that I think a lot of times their lawyers end up having to try and make bricks with no straw.
I'll take that. Again, I don't know the lawyers. I don't know what happened behind the scenes, but I'll definitely take that argument as well. I'm just saying that I would have explained to my client what was going to be the effect of that. To me, that's just the way I would do it. But we can also disagree about the strategy, and perhaps you're right. I should not be blaming the lawyers here. Again, I don't know what happened behind the scenes, and I'm sure he's a difficult client.
I wouldn't think we should blame the shareholders. I want to keep on the point for one more round here of this idea of whether or not the shareholder is helping. So the fact that we have a system that allows Tornetta to file this lawsuit, the fact that this lawsuit got heard by a court, and I understand, of course, the point that once it goes to the court, they have to deal with it because it was presented. But Steve, you seem to suggest that shareholders have too much power. Is this just another example? When 72% of shareholders agree to something twice and one person dissents, is that evidence that there is a problem with shareholder democracy? Or is this an example of how you prevent tyranny of the minority?
This isn't really a case about shareholder democracy, though, right? This is a case about what we think of the role of derivative litigation in holding people like Musk accountable, how skeptical we are of derivative litigation as a means of corporate accountability. And personally, my view is for a long time been that derivative litigation mostly tends to benefit the plaintiff's bar rather than shareholders. And I think there's a lot of evidence to support that and a lot of theory to support that. Richard Tornetta was not the real person in interest in this loss. The guy owns what, 10 shares of stock, something like that. He is the cat's paw of some very large and very powerful and very talented plaintiff's lawyers, and now can afford to go out and buy a super yacht with their $345 million payoff, which you got to give Chancellor McCormick some credit, because these guys originally asked for fees of $5.5 billion, which was just insane. But I had $345 million. If you polled Tesla's shareholders and said, did you get $345 million worth of benefit from this litigation? I doubt whether any of them other than Tornetta would say yes.
That's the real shame of this, right? It's the lawyers are the ones who won the case, and that literally. So that's a huge payday that's really important to highlight. And as Steve said, the fact that we have derivative litigation and a plaintiff's bar who can take these cases with a shareholder as 10 shares, that to me raises serious questions around whether this power is really used to drive the corporation forward. But Anat, do you have a counterexample? Do you think that allowing shareholders the rights to sue is still important?
I'll tell you what, I think it's important to follow our paper and process and good corporate governance metrics. I think this whole saga could have been prevented if from the beginning, the compensation package would have approved properly, and it should have been done. I'm sure he has amazing lawyers. The whole thing should have just been done properly from the beginning, because I don't want you to think that I'm downplaying vision or leadership. Not at all. I think it's important to have charismatic leaders. I think charismatic leaders are important for companies. I think they're important for employees, for customers, for investors, to align everybody around a shared vision and mission, to have market confidence in the company. Trust me, I am not opposed to having strong, visible leadership. Not at all, especially when we have industries that require innovation or rapid decision-making powers and authorities, okay? That's not what I'm saying. All I'm saying is just follow the rules. We have structures for a reason. It shouldn't be that hard to follow them, because we need to have some sort of checks and balances. And so perhaps you are correct. We're not looking as much at the substance as we are at the procedure, because we don't want the courts to look at the substance. We want them to look at the procedural aspects, because we don't want the courts to be the ones making the business decisions. And I think that's why we have these governance norms and structures that we put in place. And that's why we have these checks and balances. And so what I would like is for leaders, if you're a superstar CEO, just operate within the frameworks that we have. Ensure that the structures are met and don't be in those types of situations. And if you led the company in a way that, hey, you make $100 billion to our business, I don't care, and the company's profitable, but just approve in the right way. Do everything the right way. That's why we have structures, and that's why we want to have lower transaction costs and efficiencies. But that's how I look at things.
Steve, let's bring this back then to the role of the courts, which was the other issue you framed then. And is this really a case about failure of process and not about substance? In which case, it's just a reminder from a Delaware court that you got to follow the rules. You seem to think it's more than just a reminder to follow the rules. So what's your view on this being just a matter of you didn't do your paperwork right and so you got dinged? Is that the right way to frame this, or would you frame this case different?
No, that I'm in complete agreement with Anat. This is, at the end of the day, legally a process case. There's a process for what's known as cleansing conflicted interest transactions, which is that you have a process that's intended that the conflict of interest be addressed by having independent decision makers acting in good faith and who say, we would have made this decision even if this wasn't Elon Musk. The question that the case raises in terms of doctrinal issues are twofold. One is, what level of cleansing do you need? And this goes back to the point I made at the beginning, which is that cleansing conflicted transactions involving officers and directors is a less onerous process than cleansing conflicted shareholder transactions. And so that goes to the definition of controller. Right. Was the process they needed to comply with one where it would have been enough, for example, to have an independent board committee approve the transaction, which would be the case if you were dealing with a conflicted officer or director? Or did you need both independent board decision and approval by the minority shareholders, which is what the law says with conflicted controllers? And so deciding whether or not Elon's a controller was critical to that. And then the other issue, I think, is the one of deciding, okay, we're going to do cleansing. Were the directors who made the decision independent, or were we using too stringent a standard of independence? But if you had had truly independent directors, if you had had a clean shareholder vote, yeah, they would have had to have upheld this decision by the board. There is no basis in Delaware law for saying you simply paid this guy too much money. Right? There is the legal doctrine known as waste, which basically says this deal is so one-sided that no reasonable person could think the corporation's getting consideration for what it's giving up. But there's an old Delaware decision that referred to the doctrine of waste as being akin to the Loch Ness Monster. Maybe there's a case out there where you could find waste, but we ain't never seen it, and we're skeptical that it's really out there.
Anat, what's your take on how this case reflects some broader themes? So one of the themes that this seems to potentially touch on is people have really low trust in corporations today. In fact, trust in our institutions is down across the board, courts as well, legislatures, trust is down. It's a trying time in that regard. But our institutions like corporations, trust is down. And also this idea of wealth inequality is very much in the public consciousness. And although there is no law that says in Delaware you can't pay your CEO buku bucks, to what extent is this case representative of societal trust problems, trust in Musk, trust in institutions, and championing the little guy who's fighting for justice here? Do you think that's a fair framing, or would you reframe that?
It's definitely something that I hear commentators talking about, right? And that is with regards to executive compensation and corporate governance. That's a huge debate and challenge. And I honestly I don't think the court should interfere in the how much compensation a CEO should be getting. And I don't think the Delaware courts want to be there and interfering. And I doubt that the Supreme Court, by the way, because this is being appealed, I doubt that the Supreme Court will interfere. Again, that's why I say let's go back to the corporate structures that we have in place. Let's look at the procedure, not at the substance. I don't know how much Elon Musk should be paid. I don't know if he should be paid $100 billion or, you know what, the stock went up, he should get $200 billion. And I don't want to have to be the one opining on that. I don't think that's my job. And of course, people are going to complain, oh, they have private jets or oh, they had yachts. But that's out of the question here. I mean, to me, that's not, I don't want the courts having to decide if the pay is too much or too little. I think they should stay out of that. And with regards to inequality and the like, absolutely, we're going to have these discussions, but they should happen at the corporate level. And that's why you have decision makers that are managing the company. But it's a business decision at the end of the day. Now, do we need trust? 100% we need trust. And I do agree with you that we have these voices that are trying to undermine the trust. And trust is key. I said that before. I'm going to say it again. Whether it's in corporations or our financial markets or whatever it is, we have to, or our banks, we have to have trust. We need to regain trust and confidence. And to me, personally, I think we can do that through proper procedures and disclosures. That's just how I think about this situation to alleviate that. And there's other things that we can do as well. But I feel like it's perhaps a little bit beyond the scope of this. There's a project that I've always wanted to write about, and that is, it's called inclusive capitalism, because I feel like there's so much attack now on capitalism. And I know that some funds have started doing that, and that is giving more equity compensation to employees, for example, to exactly do that, to deal with some of these challenges and voices. And so,
Steve, do you think that CEOs are being paid too much? And do you think that courts should have a role in deciding any of these things? Do you have some views on executive compensation in response to Anat's comments?
No, I don't have a problem with how much most CEOs get paid. I don't think that's an issue that either courts or legislatures should be getting into. I think that's an issue for the board of directors to decide. And if the shareholders don't like it, the shareholders can vote the directors who improve these compensation schemes out of office. I do think that you want to have a process by which the board makes compensation decisions that links pay with performance. And I think boards have often fallen short in making sure that there's that link between pay and performance. But the board's role primarily to set that issue.
And how do you think this decision where the Delaware courts stepped in is going to affect Delaware? You look a lot about these issues around marketplace corporate law. This decision you think is really impactful, shifts corporate law. Does it shift it in a way that'll impact Delaware court's ability to maintain their kind of flagship prestige status as the best corporate courts? Or do you criticize the decision? Because if the Delaware courts are letting these kind of decisions go through, that might be a reason people choose to incorporate elsewhere and have their internal affairs adjudicated by other courts. What's your take on how this case is going to impact Delaware?
My take on how this case is going to impact Delaware is that it is going to raise questions for companies that have these superstar CEOs about whether they want to be incorporated in Delaware. Part of the problem, though, is we don't know yet what Nevada and Texas, which are the two most logical places for them to go. We don't know yet how Nevada and Texas are going to handle conflicted controller transactions. There is not really clear law in either of those jurisdictions. You're telling your client, if you're the lawyer advising the client, my guess is that Nevada and Texas will be less intrusive in regulating controller transactions, but I can't guarantee that. If Texas and Nevada come out with considerably more lenient approaches to controllers, then I think controlled corporations are going to start looking at relocating. We're already seeing that, as I said in my Dexit article. Most of the companies I've found that moved, and there aren't a lot of them, but most of the ones that moved were controlled companies. I also think, going back to Anat's work on unicorns, which I think has been very important and a significant contribution to the literature, I suspect that unicorns, number one, will think about not going public as Delaware corporations, that before they go public, they're incorporating probably Texas, the Nevada. There's a lot of people that'll tell you that Nevada is the state you incorporate in if you're planning on committing fraud. Very lenient, lax laws. But I think these unicorns will think about going places like Texas before they go public. And I also suspect that unicorns that are already incorporated in Delaware may think seriously about whether or not they want to go public. We've already seen, I think, increasing viability to the idea that maybe you don't need to be public. Maybe you don't want to be public. And if there's a perception abroad in the land right now that the current members of the Delaware Chancery Court, here, point to McCormick and Laster particularly, are very pro-plaintiff lawyer. Jonathan Macy, Yale law professor, has a new law review article out where he makes this point. And if whether or not that's true, the perception that's true is going to discourage people from going public in Delaware, because you're basically inviting plaintiffs' lawyers to sue you. And so I think that's the possible direction. Will it mean that Delaware loses its dominance? No, I seriously doubt that they will lose their dominance the way New Jersey did 120 years ago. But at the margins, I think it'll definitely affect Delaware and her companies at the margins opting to go elsewhere.
Anat, you seem to think that this was a good decision because it showed that paper and process is important. And in Delaware, paper and process remains important, and everyone can follow that. You're not going to get sued and lose if you follow the rules, right? So according to your view, how does this case affect the departure or not from Delaware? And is this decision good for Delaware or bad? And what do you think is going to happen with companies' decisions to incorporate?
First of all, thank you so much for this question, and also for Steve's comment, because I love his exit paper. And I have two papers that have just came out this year, and they're available on SSRN as well. One of them is called Delaware Beware, and that is beware of Texas and Nevada, for example, and also Wyoming, if we're talking about crypto companies. And the second is incorporating unicorns. Where do unicorns incorporate? And in that piece, which is an empirical piece, I found that 97% of unicorns immediately incorporate in Delaware. In the past, it wasn't like this. So 10 years ago, you would find them in California, right? Wherever they're headquartered. But that has changed. Why has it changed? Because of the lawyers who incorporate them, right? And I've been getting phone calls. I'll be honest with you. Following this decision, I've been getting phone calls from Texas. I've been getting phone calls from California. I've been getting phone calls from New York. What do we do? And guess from who is coming? Actually, from the lawyers who represent the investors, the funds that invest in these companies.
That's interesting.
Yeah. Why? Because think about it. The investors who represent funds, the lawyers who represent the investors who are the funds, they care about what's going to happen with, are they going to be able to hold these celebrity CEOs accountable? And you know what? They want to hold them accountable. And so they want to still be in Delaware because they don't know what's going to happen in Texas. And they don't know what's going to happen in Nevada. In Nevada, maybe they do. And Lipton talks about going to Nevada. You're calling, no, you can waive everything. But in Texas, we still don't know. And I looked at the composition and how they're going to do things. It's going to look very different than in Delaware, right? You have judges that are only going to be appointed for 2 years. Then what kind of precedent should you expect as an investor that invests in a fund and then invests in a tech company where, as Steve mentioned, they're staying private longer. And so who knows when they're going to go public? But what I do know is investors want reliability and they want to be able to hold these CEOs accountable. And so from that perspective, I think they're still going to lean towards Delaware.
Yeah, I hear the devil is better than the devil you don't. And maybe everyone will gnash their teeth and kick and scream and complain. But at the end of the day, 100 years of reliable corporate law, an expert panel of judges on the Chancery, a fair bit of even if you don't love the rules, you know what they are and you can play by them to a large extent. this case seemed to surprise people. You've also touched on some areas in my research. So I think this is really an interesting place to bring things together, which is that I research large private companies, in particular startups who are attempting to be large private companies. And I wrote a paper about staying private and the decision not to go public back in 2017. And that trend has increased. And what we're seeing now is companies are using tender offers. And there's even now secondary markets, which are questionable legality, topic for another podcast, around trading private stock. There's new efforts to create liquidity with stock options, because tying a lot of these things together here, as mentioned, there is this movement. It's a social movement. It's a moment in our time where equity compensation for rank and file employees is becoming more common. We're also in a moment where companies find it less and less important to go public and more risky to go public. You put your out there and it's going to get shot off by a plaintiff's lawyer who's going to be sniping at you the very moment that they get an opportunity. And these derivative suits of the plaintiff's bar is one major reason why you may want Delaware law, but you don't necessarily want to go public and face all the costs of having all that litigation. And as a result, you have these new mechanisms, which are interesting. Run 44A to its limit. And more interestingly, more recently, companies that are organizing structured tender offers to invite their employees to sell their shares back to the company in return for some company investment. And they're providing liquidity in this way and keeping the number of shareholders down below thresholds. There's a lot of efforts to avoid going public these days. It's not clear that the issue is Delaware, but the issue is going public, because the rules, which are really the federal rules around being public, maybe that's where the problem is. I want to close with some thoughts, and I'm wondering if we should stay with this. I don't know, Steve, do you see the problem as being public is not worth the expense, or do you see the problem as Delaware is not worth its benefits? What are your concluding thoughts around some of the major themes that we brought up today?
I think for most companies, Delaware is still the gold standard. I think that Delaware law has, on controlled transactions, has made some unfortunate decisions that have increased the level of uncertainty about what you need to do to process conflicted controller transactions, that have raised the level of uncertainty about who is a controller. And I think in this particular area, the Delaware Cords, if there's not a course correction, the Delaware Cords are going to contribute to, at the margins, some controlled companies opting to go elsewhere. Do I think it's going to be large numbers? No, I think it'll be large numbers. But I think at the margins, there'll be a handful of firms that. But in the long run, I think, as you say, there are still so many advantages to being incorporated in Delaware that this is more in the nature of a blip that they can fix pretty easily.
And I'd like to hear your closing thoughts too. And if you could bring in some of your unicorn knowledge here, I'm particularly interested in what unicorns, meaning large private companies, are likely to do. And they aren't subject to some of the shareholder litigation in the same way. So are they going to opt? What is your kind of prediction of whether this case will matter much, and will it be different for unicorn firms?
The first, of course it matters, because like I said, in most of those firms, we have a CEO that's usually associated with the brand, right? In most of these cases. And that's why they're a serial CEO, and that's why they're able to raise so much money. Now, you raise public markets a little bit in this divide between the public and the private. To me, I'll be honest with you, I want to see more of them going public. I think we need to encourage that. I think it's so important for even our national security. I'm not just, downplaying this. I think we need to have more companies going public. I think we need to allow more retail investors to have the ability to participate in creating wealth through these companies. And I want to see them going public earlier than they are currently going public. Now, saying that, what I do know, another thing that affects, and let's see what happens with the new administration, and that is the terms of the market, right? The market conditions also affect what we're seeing. And let's see how the market's going to react, not just to this, but overall. Are they going to be able to continue to raise funding? Are they going to be able to raise funding from different types of groups and also non-traditional investors and different players? So many things and rules and policies and regulations that the new administration is going to put in place will affect what we're going to see and how these players are going to play. And so I really hope that they'll take all of this into account when they start thinking in the long run what's going to be good for our economy. And again, to me, I would like to see more activity in our public markets. I understand there's a risk and there's exposure, but I also think what makes us so unique and other countries are envious of us is strong, healthy financial markets, and we need that.
My answer with my magic wand would be, if you want to see more companies go public, you got to deregulate, because the reason they're not going public is because we tried to make the market super safe. And the result was it's super expensive. So the incentives are all wrong. I get that, like, crisis happened. And so knee-jerk reactions from Congress, because you have to do something, was that we got to create a bunch of rules that makes being public super expensive and super risky. And the obvious choice is, well, fine, I'm not going to go play in that sandbox. Like, I'm going to go somewhere else. And there are alternatives. And that's exactly what we saw. So my magic wish, my magic wand would wave away most of the regulations in markets that have occurred since 2002 and set us back to our dot-com era markets. I think actually that's how, if you really wanted to get public markets, and I can have a longer debate about whether we do, that would be how you do it. But I think that's what the next Congress is going to have to really think about, is are they going to start repealing some of these acts? But I want to hear from you I'm going to give each of you a magic wand, and you can wave it and wish one major change, and then we'll close today's conversation. And Anat, since we were just talking about this, if I handed the wand back to you, what's the one thing you would change? It's the one law or the one ruling that you think would fix a huge amount of the problems that we're seeing in corporate law today?
Oh my God, that's a big ask. What I think, again, we should just go back to the basics. We should have clear rules. And that's what every lawyer wants, right? And when I train, I feel like the next generation of corporate lawyers, what we want is safe harbors. We don't want to have to guess. We don't want surprises. But I also think, like, I come from the law and economics perspective, where we want to lower transaction costs. We want things to be as clear as possible. So that is what I'm going to ask for.
Maybe that's what you'll get. Maybe for Christmas, for Hanukkah, we'll get you a safe harbor for controlling shareholder transactions.
I would love
that. Would solve some problems. Steve, I'm going to hand the wand to you for our last comment. What would you change if you could change one thing?
Oh, I'm so glad you went to Anat to give me a minute to think about that. The one thing that I would change would be to get back to the idea that accountability is important, but so is authority. And to get back to the idea that courts are not super boards of directors, and that, generally speaking, Delaware law works best for our economy when Delaware courts look to be deferential. They look for reasons to be deferential rather than looking for reasons to not be. That would be my magic wand moment.
Is there anything in particular you could do to make that happen? How would that be effectuated in practice? I get it. If you wave the wand in front of the judges, you change their mindset, maybe? Is it a mindset change, or is there something the Delaware legislature could do, or a decision that would have to be reversed?
I think we saw this with the reaction to the Mullis decision, where the Delaware legislature stepped in and reversed the judicial ruling in that case. I think there's a role for the Delaware legislature, but I also think that it requires you to have people like Leo Strine and Jack Jacobs and Jeff Stone and Norm Vesey, all now retired, but all of whom had internalized this idea that there is this trade-off to be made, and that their role was a limited role to intervene in a limited number of cases where accountability just became so paramount a concern. And I think part of that goes to who you put on the bench. I think at the end of the day, it's about who you decide to put on the Delaware Chancery Court. I think the Delaware legislature has a role to play, but it's not a role that necessarily they have done a good job with. You think about their interventions on things like 102B7, the Mullis intervention. These statutes are not very well done statutes. I think it's about the people that you put on the court and making sure that they have the right values.
I certainly agree that not only is it important to get judges, but I think the concept here is judges that exercise self-restraint. And this is actually something that I think would be a great conversation for our broader topics around the role of universities and other institutions in society. The world has become, in my opinion, a little activist, but I think people forget that true power is the ability to restrain yourself and make space. But I'll open that up to a debate another time. I'll just close on that thought because we've had an incredible, lengthy discussion that covered so many interesting aspects. And I just want to stop here and thank you for all of this time that you spent with us today. One thing is clear. Corporate governance is at a crossroads and has become really interesting to discuss again. So how companies manage these complexities and how lawyers enter into this conversation will shape how business will be done, whether it's going to be done as public companies, as large private entities, whether it'll be done with internal affairs regulated by Delaware, by Texas, by Nevada. Nobody mentioned Wyoming, by the way. They're trying to get in on some of the action. And this is a really interesting time to be thinking about this. So for our listeners, I encourage all of you to think about how these issues affect the companies you work for, you follow, you invest in, and what kind of corporate leaders you would choose, because you do have some role to play in that. A lot of people forget to vote their proxy cards, but you do have a chance to play a role in choosing the leaders of the corporations you invest in. And let us know in the comments below if you have thoughts around that. So with that, I want to thank the guest, Professor Stephen Bainbridge. Thank you so much for being here today.
Thank you.
And Professor Anat, thank you for being on the show.
Thank you for having us today.
Your expertise and perspective have made this an enlightening conversation. And I know our listeners have gained a lot from your insights, and I certainly have too. So if you enjoyed today's episode, please subscribe to Organize, the Business Law Breakdown. Share it with others who care about the future of corporate governance. And don't forget to join the conversation. Let us know your thoughts on Tornetta v. Musk and the issues we discussed today. You can find us on social media or leave a comment on the website. As we sign off, I'll leave you with this. Corporate governance isn't just about rules or regulations. It's also about trust, fairness, ethics, and leadership. Cases like Tornetta v. Musk challenge us to rethink what we value in our leaders and what kind of systems support the kind of institutions we want to be surrounded by in our lives. Until next time, I'm Professor Seth C. Oranburg, and this has been Organized.